So, good afternoon, good morning, good evening, wherever you may be. Welcome to this webinar, which is looking at the roles of victims in negotiated settlements. I'm Jonathan Spicer. I'm a senior asset recovery specialist at the Basel Institute on Governance, and I will be moderating today's webinar. In terms of housekeeping, there will be time for questions at the end, but we will be monitoring questions as we go along. Now, this webinar is a joint webinar between the International Academy of Financial Crime Litigators and the Basel Institute on Governance. And I'd like to invite Lincoln Kaler, one of the co-founders of the Academy and a commercial and litigation and fraud lawyer with Bennett Jones in Toronto, to introduce our webinar for us today. Lincoln.
Thanks very much, Joe, for the introduction. Welcome to everybody, and thank you for joining us. We're proud for our first joint webinar with the Basel Institute. I thought I'd start a little bit by telling you about the International Academy of Financial Crime Litigators. I co-founded it with Stefan and Elizabeth, both of whom you're going to hear from today. In 2018, we've got 80 fellows around the world in 32 jurisdictions. We're practitioners focused on economic crime litigation matters. When we were founded, we did it jointly with the Basel Institute, and we've partnered with them ever since, which again, we're very proud of working with them in initiatives, including like this. So the purpose of today is to give you a presentation with respect to a paper that we wrote along with the Basel Institute, the role of victims in negotiated settlements. We thought this was an important topic to address. One, it's very international. As many of you know, criminal prosecutions in the economic crime area have become more and more complex, more and more international, and multi-jurisdictional. And as I'm sure all of you are aware, most sophisticated criminal actions end up in a non-trial settlement, plea deals, non-conviction resolutions, deferred prosecution agreements. It's this situation, which is normal and it happens most often, but what role, if any, do victims play in that process? And as the fines get larger and larger, as the amount of money involved in these large, complex criminal and corruption matters gets bigger, the role of victims is something that we thought was important to address. And we've done that in this paper. Victims, as we'll hear, are difficult to define. It's difficult to quantify losses. And the multi-jurisdictional aspect of it makes it even more complex. As you know, all criminal law is local in jurisdiction. Crime, on the other hand, knows no boundaries. So with that introduction, I want to turn it over back to you, Joe, but we're going to hear from Stefan, who's a co-founder of the Academy and based in Paris. We're going to hear from Oscar, who's with the Basel Institute, Wolfgang, who's a fellow of the Academy and based in Germany, and Karen, a professor, a fellow, and based at the Washington and Lee School of Law. So I hope you enjoy today's presentation. At the end, as Joe said, there will be opportunities for questions, or please put them in the chat. And Joe, back to you. Thanks very much.
Thank you, Lincoln. As you've introduced, we have 4 speakers here today. Their biographies have been on the flyers in relation to this webinar. So I'm not going to go through everybody's CV. We're going to get straight into the discussion. And so for the first question, as has been alluded to by Lincoln, when we read the paper, we read about the possibilities for victims to claim or be given redress within the scope of a negotiated settlement. But it's clear that a victim can take many forms. So the first question we'd like to explore is, what are the categories of victims? Are all victims treated the same? And how can they seek redress? And so I'd like to go first, please, to Stefan, to see what your opinion is in relation to this.
Thank you, Jonathan. Yes, victims, and that's what we remind everyone in the introduction of our working paper. Victims can take many forms, and if we are talking white-collar crime, let's look at international corruption. Who are the victims of international corruption? Is it the country? Is it the competitors of the company that got the contract? Is it the people of the country? There can be so many victims. If you take antitrust offenses, well, that's even wider, I think. That goes. You take fraud. I mean, if fraud, you can have one victim, but you can have many victims. And then, as Link was reminded us, not only victims can be in one country, but they can be in many countries. And so, if you look at victims, it could be individuals, it could be companies, it could be state-owned entities, it could be countries, sovereigns. Those are extremely different animals here. And then so you have all this, and then you have a criminal process which is really about a prosecutor against a suspect, right? Or various suspects, and depending on traditions, victims are not really part of that process. Well, of course, I'm in France, and it's been a while since victims have been given status in criminal proceedings, but we know that's not the case in other countries. And we could debate actually whether the French solution is a good solution or not, but that's for another day. And so at the end of the day, in that process, really, I think prosecutors have an important role to play in identifying victims and get them notified of criminal proceedings and of their potential rights to claim redress. But are prosecutors, do they have an appetite for that? Are they really interested in making their case more complicated? And in our introduction, there's this Boeing case, right, in the States. We keep hearing about it, and we see that when you have victims, well, the life of a prosecutor is far more complicated. So will the prosecutors have an appetite to go and get and notify victims that they could have claims there that will make their life more complicated? So that's what I wanted to say at the outset. Very different types, very different animals, and then a role for the prosecutors to go after the victims, but do they really want to do that?
And I'd like to turn and ask Karen Woody, same question to you, please.
Sure, thanks, Joe, and thanks for having me. I suspect that everyone on this call will have similar answers to this particular question, given that it is a uniform sort of conundrum. Who are the victims, especially when we're dealing, as Stefan said, in this white-collar space? It's interesting that Stefan brought up the Boeing example, which of course is top of mind in the States, and I think internationally, given the scope and scale of that, and the fact that that company has gone through the few different types of buckets of resolutions already. We saw a DPA with that company, and then just in July, a guilty plea. So that will be, set aside for when we want to get into the other issues about Boeing. But when I was discussing Boeing and the new iterations of what's happening in that case, I was talking to someone about the role of victims. And in passing, someone said to me, well, isn't that the shareholders? And that is, in fairness, a very callous maybe comment, but it's another just interesting angle that there are, of course, obvious victims in the Boeing situation, but then there are, you know, the potential for stakeholders, shareholders, as Stefan pointed out, if we get into other cases that are more rife with corruption, that can be much more broad in scope. And so how does a prosecutor get their arms around who the victim is? Well, I think my first answer to that would be a fairly narrow charging type strategy. And in the States, the definition of crime victim, according to the Crime Victims' Rights Act, meaning those that was referenced in our paper, but those that have the ability to seek restitution and to have their voices heard at various points, that's defined as a person who is directly or proximately harmed as a result of the commission of a federal offense. So that's still pretty broad. That actually doesn't narrow it all from the various categories that Stefan just mentioned. So despite there being this sort of statutory definition, it still is one that can be read very broadly or in some senses potentially very narrowly. And again, that will sit with the prosecutor in terms of his or her discretion about how they even read that statute. So I know I'm not providing many answers here, but I hope I'm giving a little bit of some guidance about how it is at least handled in the States.
Thank you, Karen. And I get to turn now to Wolfgang. If you could address the same question, please.
Yeah, thanks, Joe, and thanks everyone for listening to us. The interesting thing is that in the German legal system, we have no clear rules on that at all in the phase of the investigation proceedings. It's all very discretionary. And that means it's at the discretion of the prosecutors what they are aiming for and what they insist on. And it's also at the discretion of the defense and the accused. And I would like to remind everyone that basically it's in the interest of the accused and the defense to resolve civil law claims at the same time. Because if you have to resolve the criminal law side first, and then you have a civil law complex litigation afterwards, this is definitely not in your interest. So this is second best from the perspective, not just of the victims, but also from the perspective of a defense. And what we see is a very clear picture. You typically get a full involvement of the victim under three conditions. First, is there a clearly and identifiable individual who is the victim, or is it more a crime against collective goods or involving collective goods like environmental aspects? The second question is, who is the victim? Is it clear who is the victim? And is the number of victims limited, or is it a very large number? And the third aspect is, what is the damage? Is it rather clear what is the damage, or is it very unclear? And these three issues define if you typically have an inclusion of victims' redress in a pre-trial resolution, or if you don't.
Thank you, Wolfgang. Oscar, what's the position in relation to the countries where you've been assisting, mainly in Latin America?
Thank you, Joe. Well, the question of who is the victim is actually a quite technical one, and I think it should be related to a specific legal framework. So to respond to that question, I'm going to refer to the exchanges and the research and the different cases we have had between Latin American countries and Switzerland particularly. So victims are not only regularly incorporated in Swiss criminal proceedings. There is a long jurisprudence of international corruption cases, for instance, accepting the incorporation of foreign states or even state-owned companies, or even the World Bank have been accepted in Switzerland as a private claimant capable of seeking redress in Swiss criminal proceedings. Now, the question here is how to incorporate these victims into the Swiss model of settlements, which is a summary penalty order, and how different countries, particularly in the region of the world where I'm working, it could access this possibility. And now it brings to my question where the notion of victim, which could be understood differently in many countries, and Switzerland has a very technical meaning. The quality of victim is regularly determined when we understand what is the legal object of protection of the law that we call it in French, the bien juridique, or in German, the Rechtgut. So when you are prosecuting a company for a given offense, you will need to understand what the offense is protecting so that you can understand who is the victim behind the harm. And normally, these companies, these multinational companies, are being prosecuted in Switzerland for the corruption of active foreign bribery, which generally speaking, does not protect individual rights, protect collective rights. So it will be, in the first instance, very difficult for a country to say that the corruption of active public offense in Switzerland protects, for instance, the patrimony of the foreign state, so that he can claim redress on that argument. However, in the last 10 years, in a case-by-case approach, the federal tribunal had made extremely good efforts to include the patrimony in some scenarios, so that the countries could claim redress based on the fact that his patrimony, his treasury, has been affected. Now, from the Latin American side, in this, for instance, just to take an example of the different cases that have been settled in Switzerland, the Odebrecht case, it has been analyzed in the different countries where I work, and there are tangible evidence that the different corrupt processes that this company has implemented in at least 19 countries in Latin America has provoked concrete patrimonial loss to those states. Now, how these countries are going to be incorporated in Switzerland is another very different question, but it's organized around this concept I just mentioned. Thank you, Joe.
So just to follow up with that, Oscar, then, so are each of those countries going to be able to be brought into the proceedings within Switzerland?
So the question is that the procedural code of Switzerland actually requires from the prosecutor to provide notice, to serve a notice to the victims in the preliminary proceedings. But in the context of the Swiss punishment order, they don't. And it doesn't seem that a legal consequence is attached to that. And they don't do so because of what our previous speaker said, because victims in the context of negotiated settlements are really contradictory in the sense that they will probably oppose, they will delay. Once you are admitted as private claimant in this proceeding, you have different procedural rights, one of which is to oppose the proposal made by the prosecution to the company. And therefore, the more victims you have, all the different type of victims, not only states, but intermediaries, etc., will have the right to oppose and block the conclusion of a negotiated settlement in Switzerland, for instance.
Okay, thank you. I'm going to move on then, please, to the next part of our discussion, which is when it comes to claiming redress, when the victim is claiming redress, what are they actually entitled to claim within the context of a negotiated criminal settlement? Are there limits on what can be claimed within those proceedings? And so I'd like to go first to you, Karen, and see how it's approached in the United States.
Sure. So I guess I would start by saying I take a tiny bit of issue with this concept that the victims are claiming this redress, because I think the theme of so much of this and some of the problem is that it's not, the victims are sort of a third party, if you will, to some of these processes, meaning this is, discretion of the prosecutor and then discretion of the judge. And so, as I think Stefan pointed out, there's prosecutor and there's suspect, this is criminal law. The victims, as we will, I'm sure, get to soon, have the opportunity to seek redress also maybe through a civil suit, through a private lawsuit. And so I say that because it's not really the victims moving. But given that sort of context, I think there certainly, at least in the United States, are instances where the victims have a real voice. And it depends on the process that often the prosecution has chosen. And so as we point out in the paper, there's sort of three categories of ways it can move forward for a non-trial resolution. So the first is a declination. I actually think that's a complete misnomer now in as it is laid out in the Justice Department manual, because it's not really a straight declination. They're not just declining to prosecute. It really is an NPA, but it's just given a declination term so everyone stays happy and thinks they got to win. But a declination is they decline to prosecute. However, it's with strings attached, and those strings are that they have shown that they have compensated victims as one of the mitigating factors. That, again, is what is needed to dangle the carrot of a declination from the Department of Justice. So in those situations, you don't hear much from the victims other than the company is showing that they have done what they could to mitigate the loss and the damages. Again, I would cede to the others in the academy who are doing this every day. I certainly just read and think and research about it. But I don't think there's many instances where victims are really have a lot of say in those situations. The other two categories are a DPA or NPA. In those situations, there are statutes that come into play. One I've already mentioned is the Crime Victims' Rights Act, excuse me. And that can trigger the restitution statutes that we have in the United States, which are the Victim and Witness Protection Act, was passed in 1982, and the Mandatory Victim Restitution Act that was passed in 1996. So in the instance of a DPA or an NPA, or in the third category, which would be a straight guilty plea, those statutes get to take effect, and there is a little bit more of discussion with victims, and the victims are able to make a statement, certainly in terms of sentencing. But as we saw in the Boeing example, that there clearly was a lot of discussion with the victims of the families of the plane crash, and that they were able to at least even try to attempt to sway the judge and to put in numbers that they were looking to see. The judge rejected that in the case of the Boeing DPA, and certainly rejected the 24.5 billion, excuse me, they asked for in conjunction with the guilty plea. But there is at least the avenue to try to put those numbers out there and to seek some restitution in those particular processes. I know I'm talking a lot, so I'll pause there.
Thank you, Karen. I'm going to turn to Wolfgang then, please. What would be the rights to redress, and what are they entitled to claim? All right. I'm going to ask Stefan if you could just answer. Jump in. Thank you.
Wolfgang is back, but he'll be next. If you choose so, Jonathan, of course. I mean, so interestingly, and it's good that we started with Karen on this question, because I mean, the inventors of settlements in criminal processes are the Americans, and I love hearing Karen, with all the categories you have of various settlements, and I'm sure more will be created, right? We have declination, NPAs, DPAs, guilty pleas. And it seems to be, I mean, nothing is stopping the creation of prosecutors and defense lawyers to come up with new regimes, right? So I do find it interesting, and France is trying to catch up with, but we stayed with two. We stayed with guilty pleas and DPAs. That's all we have. And so far we're happy with that. But the problem we had, and that's different from the United States, is that in France, as is the case for Switzerland, for example, right? Victims have standing in criminal proceedings, right? That's a long-lasting tradition where victims are parties to criminal proceedings. But if you give that status to victims in this difficult negotiation that is already very difficult, if then you allow victims to block the settlement, that becomes complicated. And you know, at first, when guilty pleas were adopted, victims had a say and could bar guilty pleas. But that was not something that could work, right? And gradually their rights have been lowered. They can claim in that process, they can go to court when the guilty plea is being adopted, you know, by the judge. Their victims can come up and say, well, you know, I'm claiming this and that. That's clear, and the judge will grant them damages on that occasion, right? That was the solution for guilty pleas. At first, they could block guilty pleas. Now they can't, with one or two exceptions. Now, when it comes to DPAs, well, clearly, from the get-go, it was decided that victims could not block DPAs. That's clear. Now, two things, as Karen was saying, the fact that victims have been compensated is a mitigating factor, so you will lower the financial sanction if you can demonstrate that you have compensated victims. And then if you have not, then the prosecutor will say something about that in the agreement, in the DPA, and say, well, you will pay within 1 year that amount to the victims. Now, the reality is that that's all good, but we do know, let's take the example of international corruption, and I'm seeing quite a few questions already popping up here. Have we ever seen a country being compensated in these DPAs? I don't think, I haven't seen that. And so I have a feeling that when it comes to deciding victims and victims, there's some sort of a, you know, choice being made at that stage by prosecuting authorities, and they will decide, you know, if they should compensate the country where the corruption took place or not. And I'm not seeing much of that if we talk, and I know that is of interest to this crowd when it comes to international corruption.
Wolfgang, I think we have you back.
Yeah, sorry for the connection problems I've had.
No problem.
But Stefan's remarks give me a good segue into, because in effect, the sort of in practice, although technically French and German criminal procedure is very different, I think it works very much the same way. In the trial phase, victims have full legal rights to participate and file their claim, their redress claim, but it's purely at their discretion. They don't have to, but they can. But in the investigation phase, and typically settlements are more in the investigation phase, they are not included formally. And I think this is also then quite similar to the US, because what we've heard from Karen, this was all basically a lot of policy decisions and not so much really legal decisions. And of course, the more you grant legal rights to persons or to entities, then it will get technical and it will get messy in a way, because you have a definition of a victim and of loss and of damage in tort law, and no one wants to take that away for damaged parties who are victims of crimes. And you will get an additional layer of who is a victim in the sense of criminal law to enforce these rights. And I'm frankly, the real question that we are facing is, are we having a policy decision? What is a good prosecutorial policy? Or do we think there are more formal legal rights necessary in the investigation phase that give victims or alleged victims, because in the investigation phase, the presumption of innocence applies to the suspects, or do we think it's just a discussion about the right prosecutorial policy?
Okay. Oscar, if I could turn to you.
Thank you, Joe. Yes, I think the original question you made was what can be claimed and what are the limits, right? So this actually drives me directly to the idea of also the incorporation of victims and what are the challenges of the victims facing. I fully agree with what has been said here, but in Switzerland, there is another particularity that requires that the victim itself suffers the harm personally and directly. As I said, once again, for the state, it's going to be sometimes very difficult to prove that. In some of the cases we're seeing now, Petrobras, Bloomberg, for instance, it is the state-owned company itself that would have the right to request the incorporation as private claimant in Switzerland. Now, as for the limits that can be imposed to these reparations, there is a controversy in Switzerland with regard to fines. So the corporate liability of multinationals would allow to impose a fine up to 5 million Swiss francs, while the small or simplified procedure that we are using to settle the cases in Switzerland will have even a less limit to impose fines. As I said, there is a controversy there. What has no limit, on the other hand, is the confiscation measures that could be imposed to companies. Regularly, in Switzerland, prosecutors calculate the confiscation, the value-based confiscation they are going to order against a company on the gains that the company has obtained through the corruption-tainted contracts. So, and also just to respond to Stefan, in some of the recent cases that we see, the prosecutors in Switzerland start to allocate some of the confiscated money to the victim state. In the Gumber case, for instance, Ecuador has been allocated 25% of the almost $400 million that have been confiscated in this complex of facts. But this confiscation had been made unilaterally. It's not Ecuador that has provoked the compensation, because Ecuador has never been alerted that the settlement was going on in Switzerland or in the United States. They have learned about it by the press or by other reported channels, and only later are trying to become private claimants in Switzerland and negotiating with the company to obtain redress. Thank you, Joe.
Okay. And turning then to our last question. The legislation in some states doesn't contemplate any form of redress for victims in negotiated settlements, other than for the most straightforward loss. And I take for an example here the Airbus case in the United Kingdom, where there were also settlements in the United States and also in France, where the number of victim countries, the issue of compensation was raised in the final approval judgment issued in the High Court, and it was made clear that the judge didn't consider the issue of compensation because assessing what compensation would be awarded was going to be far too complicated. And the suggestion was that they should go back and look at their civil rights, or their rights within, to bring in action within the civil courts. And so the last question that I'd like to ask to the panelists is whether that's the right approach. Should there be a greater role for victims within that negotiated settlement agreement? Should we expect more effort to be made to grant redress to victims? where the criminal proceedings are being compromised. And I take that from an approach of you have parties that are trying to reach an agreement, as opposed to where a judge is trying to, after the event of a trial or a guilty plea, assess those damages. So I'm going to ask Wolfgang, how would be the approach in Germany to that? And is there a scope for strengthening the rights for victims in German criminal proceedings?
Yeah, thanks, Joe. No one wants to take away the victim's freedom to claim compensation before the civil courts. So anything they have in the criminal proceeding is only, and this means that there is, and I also think there needs to be a certain degree of discretion for the victim if they want to claim before the criminal court and to resolve it, not just claim, but also resolve their claims. And of the accused, the company typically who has the money, not the individuals, and of course the prosecutors. And I would rather be very skeptical on any restrictions for that discretion, with one big exception that we haven't looked at so far. And this is the scenario of profit disgorgement of a feature. Because typically, the profit in an economic crime should correspond to some extent to the losses suffered. And now if the prosecutors disgorge the profits, they basically take away the money that's coming out from the losses. And in that scenario, I think there should be clearer rules, and it should be made very clear legally even that if the prosecutors go for profit disgorgement, they have to ensure that the money that they're siphoning off is going to the victims and not to just one of the many jurisdictions that are prosecuting.
So what you're saying there is that there's a risk that with the huge fines that have been imposed on companies based on loss of profits, there's a big risk that when the victim comes to make their civil claim, that there'll be no money left.
Or that the accused company pays twice. Exactly.
Yeah, indeed.
Or if punitives in the US pays three times or four times the actual loss and the profit.
Well, let's go to you then, Karen. Is it 3 times or 4 times the actual profit?
Well, it's always hard, as you know, speaking from a former defense attorney, it was always hard to actually get the number around the exact amount that was ill-gotten gains that need to be disgorged. But given that, there can be certain different bites at the apple. We've seen that even in just this Boeing case we keep coming back to. And so I think the disgorgement issue is a big one, especially where those funds go to. In the United States, there is a much bigger push to have those go to certain accounts that hopefully would at least have some amount of that dog-eared for victims' restitution funds. And we saw that even in the Boeing settlements. But, you know, as I mentioned earlier, there is a mandatory Victim Restitution Act that attaches once you're in more of a process, including even in plea agreements in the United States. It's still somewhat nebulous. I mean, restitution is defined that it can include things like obviously any property taken or any value and other certain payments. There was actually, I think, relevant to this group's interest, there was a case in 2018 that limited it because one of the things that counts as restitution can be expenses and costs incurred related to investigations and criminal proceedings. And after a 2018 case, it was called Lagos versus United States, the court said that is capped at the criminal proceedings when it includes government investigations, but not also the private investigations or any civil or bankruptcy litigation. Because as we know, the cost here can be inordinate. I mean, sort of exorbitant, I guess is the word. So I think there certainly is an attempt to try to get our arms around certain areas of restitution that victims can claim, and certainly have a right in the United States to claim, but with certain limitations. And again, almost entirely can be at the discretion of both prosecution and the judge. There'll be some ability to move those numbers. It's not an absolute defined set amount.
Okay. Oscar, can I turn to you? I expect you're going to tell us that there should be more effort for the victims to be heard.
Yes, I actually also agree with Wolfgang to the fact that victims should not be limited to one or two procedural routes to claim compensation. The principle in Switzerland has always been that a civil claim could be sorted out in criminal proceedings only to a certain extent. If the civil claim becomes really complex, victims has always the possibility to go before a civil court and claim compensation. I also need to say that actually in Switzerland, there is no a DPA or plea guilty per se. What we have is just a creative way of organizing simplified procedures in order to reach a similar result, which has actually, it has been designed for small offenses, actually, for petty claims regarding civil compensations. But as I said before, it has been extended and continues to be extended to incorporate victims of another very different scale. Now, I'm fully aware, actually, of all the problems that victims provoke in the different negotiated proceedings, and I fully agree as well. But the fact that so far there have been important disgorgement of profits in Switzerland, not only in Switzerland, but with regard to the cases I'm saying. For instance, the fines imposed to Odebrecht were $3.5 billion in 2017. 19 countries in South America, they have not received one single penny out of that money. No, that is the other extreme of the situation with which, in my opinion, should be reviewed. And not only that, also claiming on the victim states. Not only the damages can not only be measured on economic terms. Also, these countries need to prosecute their own authorities, their own corrupt those who took the bribes. And in the context of the different settlements, we have tried several times from different countries to obtain mutual legal assistance, for instance, to obtain evidence. And it has failed all the time because these proceedings are, I think, really focused on what's going on in the receiving country without taking much into account, except for calculating the damages, of course, the victim countries. Thank you, Joe.
Okay. Thank you. I'm going to turn then to Stefan. What's your view on this subject, this topic?
Very quickly, because we want to leave time for questions, right, Jonathan? I'm
Yes.
going to say that it is important for victims to get their acts together. We've described, victims. There can be so many victims, and it's not the prosecutor's job in a very complex case to assess every victim in the case. So it's really important that victims get their acts together and claim. And I must say, when particularly when we are talking countries, when they're not making any effort to claim anything, and then suddenly they wake up and say, hold on a minute, I could claim a little something here, while they haven't, as Oscar was saying, while they haven't prosecuted anyone in their own country, I must say I have limited sympathy for that. Victims I think it's important that it's an important process when we talk about corruption. Well, you want to claim, do claim, and organize yourself to claim with the assistance, of course, of the Basel Institute of Governance. I'm all for that, for sure. But at least there needs to be a will there for victims to claim. It's not about we are not getting anything and the world is awful to us. And no, get your acts together, claim. I know it's easier said than done, but very often we see victims not getting their acts together, not claiming properly. Yeah, it goes with loopholes. It's not easy, but you know, your institution, Jonathan, is here to help for that. So I think that's important. I would also say a second comment would be to say that you have criminal proceedings and you have the civil proceedings, and I think our paper touches upon this in the conclusion. There needs to be ways in civil proceedings to get access to evidence, to get access to the criminal file, possibly, right? I think that's important. If we want the civil route to be effective, there needs to be an easy access to evidence. And I would say that in the countries we are dealing with today, this access is very, very limited. So there needs to be something. I mean, if the civil route is to be contemplated and should be contemplated, it's got to be made easier for the victims. Final point: yes, there's a conflict between the confiscating state and the victims, and I must say that confiscating states are somewhat reluctant, very reluctant, to give the money back once they have confiscated it to victims. That's and I've got quite a few examples of that, and I must say that I find this, you know, I do understand the taxpayers' money issue from the standpoint of the confiscating state, but that shouldn't go against the right of victims to get redress.
Thank you, Stefan. And I think that sort of last point that you made there sort of really goes to the heart of the controversy and the debate, that the confiscating state can make huge profits, where the rights of the victims are left to one side, and they're told, we'll go to the civil courts because it's too complicated for us to make that decision. I'm going to turn then to the questions that we have in the chat. I'm going to quickly read through them. Apologies for not having been able to keep an eye on them as we went along. I think this question here comes from Anna-Marie Pekridou. She asks, would you consider that the current international standards, for example, UNCAC or the OECD Anti-Bribery Convention, oh dear, I've just lost that. Sorry. Or the OECD Anti-Bribery Convention can provide some guidelines on the means that member states shall identify the victims of corruption-related financial crimes. So can the current international standards provide some guidelines for which member states are able to identify victims of corruption-related financial crimes? I'm not going to pick on anyone in particular out of our panel who would feel confident to give an answer in relation to this.
Karen, you want to go for it?
I was looking at the Bonny Island question next too, but we'll start. You know, we reference the OECD even in this paper, but ironically, sort of in the countervailing notion that sometimes that the inclusion maybe of victims can, as I say, sort of re-corrupt some of the process. It's an interesting quote I think we picked for the introduction of this paper, but I think highlights just that. There are, I think, a lot of stakeholders, a lot of interests in this, and I do think there is something to be said that the Convention Against Corruption and the OECD have valid ideas and guidelines. I would also just point out that maybe unsurprisingly, those are not going to be heeded all of that much, maybe by various U.S. attorneys in the United States or the DOJ. That's very persuasive evidence, but it's not something that would be binding. But I think, as you point out, I think it's a good guidepost, a good metric for people to use. But I don't know that that would be necessarily, it certainly would not be binding. And I think, so I'll leave it there.
Okay. I'm going to go on to the next question, which is in relation to Nigeria. And the question that is put, and I'm going to slightly ask the question to you differently, but it included Eni being Eni, the Italian oil giant, and Halliburton, a US oil services company, among others, paying a total of 1.28 billion in fines to the DOJ and SEC for bribing various Nigerian government officials with over $180 million. And the bribe was made to obtain contracts worth over $6 billion to build gas production facilities within Nigeria. And the question asks, Article 35 of UNCAC urges state parties to provide for compensatory damages to victims of corruption, such as states and local communities. However, neither the US courts nor the DOJ has awarded damages to third parties or to the Nigerian communities that has suffered harm. I'm going to slightly reword this question. Is this current method of enforcement of these FCPA-related offences towards US oil companies, is it not overlooking the interests of the citizens of the country involved, and particularly those communities that are affected by these bribes and these acts of corruption? And I'm going to put that to you, Karen, I'm afraid.
Right. All right. Well, I mean, first, Bonny Island, that sort of sting, that massive investigation that implicated so many companies over years. I would imagine most everyone on this call had some exposure or involvement in defending that sort of amount. It was just massive. And I would also say this is a bit of, for lack of a better term, the golden age of FCPA prosecution. This really was the DOJ and the SEC coming in hard against all these things. My thought about that, of course, that is corruption. But if we step back, and not to undercut the point, even if that had been contracts that had been legitimately awarded without maybe the significant amount of bribery, the issue is that it's hard to reach, it's hard to point out where, you know, it's hard for the United States to step in and say, by the way, the use of these funds in Nigeria are defrauding or is harming the citizens of that particular country. So I do think the United States didn't feel that they had that extraterritorial reach into allowing for that that type of restitution to run all the way to the citizens of the country, despite, I think, the terms of Article 35, and that is a really important term that I think should be taken very seriously. I think the other victim here, to some extent, and I know this seems that pales in comparison to the citizens of Nigeria, but a lot of the other people who were screaming and their hair was on fire about this were the competitor companies who didn't get these contracts because they weren't bribing. So should there be some sort of compensation to people who lost out on all these contracts because they were following the law? This just opened up so many cans of worms in all of these various prosecutions, and in sort of this wholesale really sting on the oil and gas industry at this point, that you could see to some extent how, unfortunately, the voices of the citizens of Nigeria got lost in these major sweeps. Okay.
Thank you. I'm just going to raise one of the comments in the questions, and it's really addressed to you, Stefan, where it's a comment that is made that it's not always the case that law enforcement in developing countries are able to get their acts together and bring a claim because they've been weakened as a result of the state capture by multinationals who are the parties to the non-trial resolutions. They say that this weakness of the victim state is not always a result of a lack of will on the part of prosecutors. And so that may actually be a reason why, even though a third state is taking action against the companies, it may not always be possible to prosecute within the countries where the corruption took place. I don't know if you have any comment to make on that. I suspect you probably agree.
Yeah, I mean, very fair comment from Colette Ashton, and she's quite right. But you know, there's been attempts. We know there's been attempts to give money back to countries that have not been particularly proactive in getting money back. Mm-hmm. And those attempts are not complete. I mean, look, we have the problem in France. We have the problem of Equatorial Guinea. How are we going to give the money back to Equatorial Guinea? Looking forward to seeing tangible results. Because the problem, I agree, the country has been weakened. But the country is still in the same state, and the money we're going to give back is going to be funneled again in the same corrupt system. And I think the Basel Institute is good for that. It's rather helping those countries getting their acts together, because that's a good process, rather than giving them charity, right? Being charitable to them, and let's give them money back. And you know, if they don't change, if they don't evolve themselves, and let's help them to do that. But let's not, you know, keep on doing the same thing, give the money back through aid, and the aid is being, you know, there again, going into circuits that are not efficient. I think there is a sensible process in helping countries getting the money back themselves, with our help, of course, but making that effort is really important, because if they don't do it, if they don't make that effort, things will stay the same.
Thank you. Well, we're nearly out of time in relation to our seminar. So before Elizabeth makes some closing remarks, I'm just going to quickly reflect on what we've heard today. What we've heard is that we know that identifying a victim is not as simple as we might initially think in relation to these proceedings. There are many, many different forms of victim where bribery is concerned. We also see that the rights of victims in relation to the criminal procedure can be different depending on the legal tradition. In terms of if I could put it, the more common law tradition, as we see in the United States and the UK and other countries, victims don't really have that status, that locus to appear within the proceedings, and they rely very much on the prosecutors. Whereas in the civil law jurisdiction, we can see that within France, within Switzerland and Germany, the victims do have a status within the proceedings, but they have to be invited in by the prosecutor, and that's not necessarily always the case, that the prosecutor identifies the victim and brings them into the procedure. And part of the reason for that is because it again makes the whole issue so complicated. And what if I can summarize this way, we appear to be in a situation where we should encourage the compensation of victims within these negotiated settlements where it's possible to do so, but also to recognize that they still have very real rights to bring action within the civil courts. And within those civil courts, it may well be that their ability to claim redress is actually better served than within a negotiated settlement, which is not necessarily designed to identify the damages and the loss to victims. And so with that rather pithy overview of contributions of our experts, I'm going to turn to you, please, Elizabeth, to your closing comments.
Thank you, Joe, for wrapping us up on such a complex discussion. Thank you to our lively speakers and to all of the authors on our working paper about what's in it for the victims when white-collar crime prosecutions end in negotiated settlements. Victims are difficult to define. It's difficult to quantify damages. and crime knows no boundaries, as we heard from my co-founder Lincoln earlier today. What we know is that having an economic crime litigation partner makes a difference. And that's precisely why the Academy and Basel joined forces. To the late Greta Fenner, a giant anti-corruption fighter, I hope today's efforts made you proud. Dear fellows, colleagues, thank you, as always, for your continued support and dedication to our cause. Here's to transparency. Here's to continued dialogue on these complex issues. And we hope to see you again the next time. Until then, take care, and we'll see you soon.
Thank you, Elizabeth. Thank you to our panelists, and thank you to all of you who've taken the time to watch. We've now closed the seminar now. Thank you.